facet of democracy on January 6th. The tweet was posted by Judge Michael Luttig, a former federal judge of the U.S. Court of Appeals for the Fourth Circuit. He joins me now. Judge Luttig, so much has happened since then. I thank you again for your service to the country, but it's evolved, right? Back then you were talking about what the Constitution allowed the vice president to do as it related to the transition of power. Now you have recently, since I think August 19th, taken up the cause of Section 3 of the 14th Amendment of the United States Constitution about whether or not Donald Trump is eligible to run for the presidency of the United States. And in the couple of weeks since you and I have still last talked, so much has happened. You may have just heard my conversation with the Colorado Secretary of State. The Supreme Court is on February 8th going to take up this matter. I'd love your thoughts on that.
Thank you, Ali. This issue was always destined for the Supreme Court of the United States, and obviously the court itself understands the momentous importance of the Colorado case for the country. This will be one of the most consequential Supreme Court decisions for both American democracy and for American politics since the founding of the nation. Ali, the genius of the Constitution is that it belongs to the people of the United States. It belongs to the American people. The Constitution is the great charter of our self-governance, and it majestically begins, "We, the people of the United States, in order to form a more perfect union, do ordain and establish this Constitution." This is one of the rarest moments in constitutional history where literally millions upon millions of Americans are interested in and riveted on the meaning of their Constitution. Every American can read the single sentence of the disqualification clause of the 14th Amendment and understand that the former president violated the Constitution when he attempted to remain in power after his 4-year term had lapsed, preventing the peaceful transfer of power to his successor for the first time in American history. Very often, Ali, the meaning of the Constitution is as plain to the people, if not more so, than it is to the Supreme Court of the United States. This is one of those times. The framers of the 14th Amendment envisioned precisely this moment when they wrote the disqualification clause of the 14th Amendment. The moment when, despite losing a presidential election, a president of the United States would attempt to remain in the presidency beyond his 4-year term and prevent the peaceful transfer of power to his successor, who had been elected by the American people. It is this violation of the Constitution that constitutes an insurrection or rebellion against the Constitution of the United States within the plain meaning of the 14th Amendment.
It's Michael Popok, Legal AF, and that was Judge Michael Luttig, right-wing Federalist Society. He's on the Mount Rushmore of judges, and he is largely credited with having tweeted to save democracy when he opposed Donald Trump, shored up a wavering Mike Pence, and provided him with the appropriate legal advice on Jan 6th of 2020 that Mike Pence did not have the power or the authority to do anything but certify the election for Joe Biden. Now, Luttig, Judge Luttig, has gotten off the sidelines and made protecting democracy a contact sport, and he's in the game. You just heard a clip from a interview that he gave on the anniversary of the 3-year anniversary on Jan 6th. And let me just unpack this for you and tell you what his working theory is. And it's been expressed in a brief that Judge Luttig and others that used to be in 5 different Republican administrations have sent in and will send in to the United States Supreme Court. The 14th Amendment to the United States Constitution was passed, and Article 3's disqualification clause, not by the original framers of the Constitution, but later during our Reconstruction period after the Civil War. And according to Judge Luttig, who's a constitutional scholar in his own right, The reason it was put in there is exactly the reason that we're presented with today. The problem of a president who have lost his first term refuses to peacefully transfer the reins of power to his successor, to the winner of the election. Scour the United States Constitution, the We the People living document that that Judge Luttig talks about. Nowhere in there is a circuit breaker that says, what are you supposed to do if somebody like Donald Trump refuses to leave office unless you pry it from his cold, dead fingers? What do you do? And what Judge Luttig says is, that is what the 14th Amendment, Section 3 is exactly for. When a former president, a one-term president, refuses and rebels against his constitutional obligations under the Constitution, specifically Article 2 of the Constitution. That is what has been baked in to the Constitution, and what you do when you have a president at the time like Donald Trump who refuses to leave. You look nowhere else. It's already in hiding in plain sight. And it's so obvious and so reasonable an interpretation that, according to Judge Luttig, and I agree with him, the American people, this is the We the People document, this is our governing charter, they can interpret it sometimes better than the United States Supreme Court. And so all of this misdirection play that's been going on by lawyers for Donald Trump who are not constitutional scholars, who say that, who have tried to convince judges and others that the 14th Amendment Article 3, dealing with disqualification, has to do with whether Donald Trump incited a riot or took a pitchfork and a burning torch to the cradle of our democracy on Jan 6. That's not the insurrection or rebellion that Judge Luttig believes it is, or that is at the foundation of this analysis. The rebellion and insurrection is against the Constitution and the obligations of a one-term president under Article 2 of the Constitution to turn over the reins of power peacefully in a transfer to the winner of the election. That is the rebellion. That is the insurrection against the Constitution, the document, the governing charter with the social contract with the Americans. Yes, the Jan 6th attack, right, is a scar on our democracy led by Donald Trump, caused by Donald Trump. But the constitutional violation against his oath is his refusal to transfer power. And right in front of us is the owner's manual to remove him. Or as Judge Luttig said, it's right there. This is exactly what the framers of that particular, the drafters of that particular provision during the Reconstruction period in this country after the Civil War, this is what they worried about. They worried about a future Donald Trump refusing to leave office. And then what do? As you scroll through the sections and amendments and articles of the Constitution, how do we get rid of him? And what he's saying is, those framers and the legislative history would point you immediately to, well, just look to the 14th Amendment, Article 3. Section 3 of the 14th Amendment. Just look there. It's exactly there. It's hiding in plain sight. It's as plain as the nose on your face, is what the drafters of that provision would if they could teleport themselves to today, they would say, it's right there. Use it. And this answers the question, or answers the attack by Donald Trump's lawyers like Alina Habba and John Lauro and Chris Keiss, none of them, all constitutional lowlights, none of them having any kind of background or experience at the highest levels of scholarship related to this provision, for them to get on whatever shows they're on and declare that there has to be an indictment of Donald Trump and a conviction for insurrection or rebellion against the Constitution. Wrong. That is exactly the opposite. That would turn the Constitution and this provision on its head. It is self-actuating. It's self-effectuating. You don't have to do anything. All there has to do is there has to be determination by an august body, a court, a Jan 6 committee, that says that this person engaged, not convicted, not indicted, engaged in insurrection or rebellion against what? Not the Capitol dome, the Constitution. And therefore, the Constitution is self-healing. It has a provision within it. It has the antidote for the poison. And the antidote for the poison is to declare that the person has engaged in insurrection or rebellion and to make sure he can't take office again. It's right there in front of us. And so for Judge Luttig and people like us on the Legal AF and on the MeidasTouch network, while the Supreme Court is going to squirm and John Roberts is going to have to try to find, 5 votes to rule something about whether Donald Trump should be on the ballot or not. And it's not just about Colorado and Maine. Yes, those are the 2 states who have already ruled, Maine with its Secretary of State, Colorado with its Supreme Court, that Donald Trump engaged in insurrection or rebellion, primarily foundationally based on the Jan 6 report, and has banned him from the ballot subject to the appeal. It's on hold subject to the appeal. But there are 30 other states, There are 30 other states that are considering some form of a lawsuit, Secretary of State action or the like, to ban Donald Trump. We're running out of time here. So while the Supreme Court may look for, as Judge Luttig said, different exit ramps, we don't want to touch the constitutional question. This is a political question. It should go back to the Congress. It doesn't say that in the 14th Amendment at all. And any sixth grader can read it exactly the way it says and apply it exactly what's on the page. So they may want to try to find, using all sorts of constitutional and doctrines that they've developed, case law-driven doctrines. We're too close to the election doctrine, the Purcell doctrine. We don't like to make constitutional decisions at the Supreme Court. We do it only on a limited basis, constitutional avoidance doctrine. Standing, we don't think somebody has standing to make this argument doctrine. To try to avoid what Judge Luttig has said is the most consequential Supreme Court decision since the founding of our nation, and they need to take it on head on, as opposed to just saying, yuck, we don't want to take on this decision making. That's what they get paid for at the United States Supreme Court as a co-equal branch of government in our system of government, in our constitutional republic. That's their job. Do your job and do it the right way. And if you do it the right way and analyze it the way one of your own brethren, someone you look up to on the Supreme Court, many of you on the United States Supreme Court either were colleagues with Judge Luttig or you were his law clerk, or your law clerks were served time with Judge Luttig. That's how respected he is within the Federalist Society. This isn't some crackpot Democrat that they don't like saying it. This is a lion of the Federalist Society bar and bench speaking these words. And now we're going to have the United States Supreme Court, led by John Roberts, the Chief Justice, have to make a decision. Are they going to make the most consequential decision since the founding of our nation about whether a one-term president can cling to power and use violence and other methodology in order to try to stay in office, or not? Or has he engaged in rebellion against the Constitution and the constitutional oath that he took as a federal officer? Judge Luttig is not buying any of the other ways to analyze this. That the President of the United States was excluded from the 14th Amendment, Section 3. That it doesn't apply to him. It's not the right office. He's a different type of officer. Wrong. It's the exact opposite. To follow Luttig's theory, which is right, this is the escape hatch. This is the antidote for the poison for a president who stays too long, because there is no other provision in there. There is no other provision. What would people, if the 14th Amendment, Section 3 didn't exist? Let's play this out. Let's play this thought game out for a moment. Thought experiment. It doesn't exist. Nowhere. Okay, so there's no other provision in the United States Constitution. So what's supposed to happen? So in this world that I'm positing, Joe Biden is supposed to set up a shadow government down the street in some hotel, along with his cabinet, his shadow cabinet. And then he's supposed to go to the military and what? Ask them to support him because he won the election and to get that other guy out of the White House? That's the alternative? Because the alternative can't be a world where Donald Trump refuses to go and the American people and the constitutional republic can't do a thing about it. That can't be the world that the framers and the founders left us with. And that's Judge Luttig's point. There has to be a decision. As unseemly as the Supreme Court may find themselves in, we'd rather not. You have to. You have to. Because this will not be the last Donald Trump. Donald Trump might not even be the last Donald Trump. Suppose he won the election, God forbid, in November. And he didn't want to leave after 2 terms. I want to stay a 3rd term. People love me. People love me. I'm loved. I'm smart. I'm the best. I'm the greatest. And I'm not going anywhere. And I pulled it off last time. What are you going to do? What are you going to do? Who's going to convict him? Who's going to indict him? So if you don't nip this in the bud now and reinstall the guardrails around our democracy, you can see where there'll be somebody worse than Donald Trump, whether his last name is Trump or not, in the future. And so for Judge Luttig, who participated in a brief telling the Supreme Court basically that if you look clearly at Article 2 related to the presidency. This is a brief that he wrote that went to the D.C. Court of Appeals related to whether Donald Trump has immunity from criminal prosecution. But that brief is going to end up going to the United States Supreme Court when the D.C. Court of Appeals rules later this month that Donald Trump does not have immunity to dismiss his indictment in the District of Columbia. And it goes up to the Supreme Court. And they're going to hear from Luttig again, who wrote an amicus brief along with one of my law partners, Nick Rostow, representing 5 different Republican administrations, and lawyers and senior officials within it, who are about to tell the Supreme Court, you look at Article 2. Look at Article 2 about our presidency. It's the only thing that governs our presidency. It's the only place to look in the Constitution. And there it talks about, basically, it is embedded in there, the concept of a peaceful transfer of power. And if the guy who occupied the office won't leave, right? Not only is that a crime for which he cannot have immunity, because it would undermine the built-in circuit breaker within the Constitution to take him out of office, right? That's their argument there. But in addition to that, it would undermine the 14th Amendment and Section 3, because it would allow the person in the office to flout his responsibility to peacefully transfer, which is a rebellion against the Constitution or an insurrection against the Constitution. It's the only way this can be read. So we're going to have to follow what happens. Full briefing is going to be at the United States Supreme Court level for the next month. February 8th, there's going to be an oral argument before all 9, maybe 8, if Clarence Thomas grows a conscience between now and then and decides to drop off because of his intractable conflict of interest because of his wife, Ginny Thomas, being effectively one of the organizers of the insurrection, bussing people in on Jan 6th, testifying before the Jan 6 committee, tweeting and texting incessantly elected officials and election officials to try to get Joe Biden out of office and deny him his win, including Mark Meadows, who's now an indicted co-conspirator in Georgia. But it'll probably be 9 people up there. We'll be able to report on it because they'll have audio recordings that we'll be able to report on at that time. But you understand what the importance is. And I want people to have clarity of thought about what is the insurrection and rebellion at the heart of the 14th Amendment, Section 3, because it is not the attack on the Capitol. That is the byproduct of it. That is the most spectacular, Capitol in flames imagery moment, searing in our memories forever and in the historical record against Donald Trump. That's not the insurrection or rebellion. It's the failure to transfer power as required by Article 2, which constitutes insurrection or rebellion against that living document, the We the People Constitution. We'll continue to follow whether Judge Luttig's analysis holds sway with some of his students that now sit on the United States Supreme Court. Only one place, Legal AF and the MeidasTouch network. Help them get to 2 million free subscribers and follow our show Wednesdays and Saturdays at 8 p.m. Eastern Time on the YouTube channel and then on audio podcast platforms of your choice. Leave me a thumbs up. It helps. Leave a comment. It helps. Helps with the ratings. Helps keep this kind of content on the air and coming to you. Until my next hot take, Till my next Legal AF, this is Michael Popok reporting.
Hey Midas Mighty, love this report? Continue the conversation by following us on Instagram at MeidasTouch to keep up with the most important news of the day. What are you waiting for? Follow us now.